Yo, what's up? Sean G, Podcast with Soul. Welcome to the channel. Make sure you share this video, hit the like button, subscribe to the channel. You can follow me on TikTok, Podcast with Soul, Instagram, Podcast with Soul, YouTube, the Podcast with Soul, Spotify, the Podcast with Soul. Everything we're going to talk about today is public information. We do not wish to slander, libel, or defame anybody as it relates to what we're going to talk about today in this video. Yesterday, August the 26th, in the state of New York, Supreme Court of the state of New York County. Yesterday, Justice Stroth of New York State Court dismissed in its entirety one of Tony Buzbee's firm's pending cases. The sole claim for sexual battery under California law was dismissed as untimely. The court found that New York Civil Practice Law and Rules 213-C, which provides a 20-year statute of limitations for torts based on criminal sexual offenses, does not apply retroactively to allegations predating its 2019 enactment. Because plaintiff's claims accrued in 2015, the court dismissed it in full. So what we have here is a lawsuit filed by a John Doe, by some dude who doesn't want to give his name. And what he alleges in this civil suit, Tony Buzbee, his attorney, is that sometime in 2015, he was at this club, Club QC 2020 in Los Angeles. He said that he is not sure, but he thinks Puffy gave him a drink. The drink was laced, it knocked him out. He woke up and there was some sexual activity going on, and he is a victim, and he sues Puffy in a civil matter in the state of New York. Now, what happens is, being that the incident allegedly took place in California, the statute of limitations has to be satisfied in California and New York. Why they filed this in New York when the incident allegedly occurred in California, your guess is as good as mine. But this is a Tony Buzbee case. We know that from past the history of this man, Tony Buzbee. He has had issues with the New York Bar Association, the California Bar Association, as being a practicing attorney misconduct and being unethical. Here is another one of his lawsuits that gets dismissed. So it's crazy what goes on. Now, in the state of New York, what was crazy about this when I did the research, SPLR, Civil Practice Law and Rules, is that when a plaintiff files a civil suit against somebody, the court automatically assumes, if I read this right, that whatever they put in the lawsuit is factual, and that it's up to the defense, the defendant, to prove that it is not factual, and that all of the benefit of the doubt is given to the plaintiff. Let's get into it. In 2015, plaintiff Jane Doe, an aspiring music artist, was invited to perform as an opening act at QC's 2020 nightclub in Los Angeles. Defendant Sean Combs allegedly, this is the lawsuit, allegedly attended the event, and according to the plaintiff, whose fake name is John Doe, files a lawsuit under a fake name, expressed an interest in potentially working with Puff. The plaintiff, John Doe, alleges that during the after party, he was given a drink believed to have been provided by Puffy after which he became disoriented and lost consciousness. While drifting in and out of awareness, the plaintiff claims he witnessed sexual activity involving Puffy and others, and later awoke to find Puffy engaging in unwanted sexual contact with him. Plaintiff asserts one cause of action for sexual battery pursuant to California Civil Code 1708.5 against Mr. Combs and the associated business entities defendants alleging they enabled or failed to prevent the misconduct. So he not only sues Puffy individually, he sues Daddy's House Recording Studio, Bad Boy Records, Combs Global, Bad Boy Productions Holdings, Bad Boy Books Holdings, Bad Boy Entertainment LLC. This shit is crazy, man. He alleges this happened with Puff and Puff alone, but he sues all of the companies related to Puff, saying that the companies should have prevented the alleged conduct from Puff. You can't make this up, man. On a civil practice law and rules, a motion to dismiss, check this out. A defendant bears the initial burden of establishing prima facie that the time in which to sue has expired. That's on the defendant to prove that. In considering the motion, a court must take the allegations in the complaint as true and resolve all inferences in favor of the plaintiff. So anybody can say anything in a civil suit. According to civil practice law in the state of New York, and in considering the motion, a court must take the allegations, whatever they say, it could be total lies, but the court must assume that it's true. Upon such a showing, the burden shifts to the plaintiff to raise a question of fact as to whether the statute of limitations was told or otherwise inapplicable, or whether it actually commenced the action or interposed the subject cause of action within the applicable limitations period. The plaintiff's submissions in response to the motion must be given their most favorable intendment. Pursuant to civil practice law and rules 3211 subsection A subsection 7, a party may move to dismiss a claim on the ground that the pleading fails to state a cause of action. Upon such a motion, the court must accept the facts alleged as true, that's crazy, and determine simply whether the plaintiff's facts fit within any cognizable legal theory. The complaint shall be liberally construed and the allegations are given the benefit of every possible favorable inference. This looks like this lawsuit was filed by an attorney who was looking for the easiest way to get his case heard. They found the most sure shot way to get their case before a judge. Puffy's defense moves to dismiss this complaint pursuant to civil practice law rules 3211 subsection A subsection 5, arguing that the plaintiff's sole cause of action for sexual battery is untimely under New York's statute of limitations and must be dismissed. New York's borrowing statute, when a non-resident plaintiff brings a claim based on conduct that occurred outside New York, the action must be timely under both New York law and the law of the jurisdiction where the cause of action occurred, meaning California. The plaintiff is a California resident, and the alleged events giving rise to this action occurred in California. Accordingly, civil practice law rules 202 applies. The defendants contend that plaintiff's claim sounds in common law battery is therefore governed by a 1-year statute of limitations. The version in effect at the time of the alleged conduct in 2015 provided a 5-year statute of limitations. Although the statute was later amended in 2019 to extend the period to 20 years, courts have held that the statute making it retroactive, the statute extending it to 20 years is not retroactive, meaning you can't go back and apply it to anything that was filed prior to 2019. The Supreme Court of the state of New York concludes that the claim is untimely under California as well. Accordingly, because the action is untimely under both New York and California law, it will be dismissed against Puffy and all of his defendants. The plaintiff's claims are time barred under all theories of liability. As such, plaintiff's complaint is dismissed. Having dismissed the complaint, motion sequence 004 is denied as moot, and there is no matter remaining before this court. The court has considered the remaining arguments and finds such unavailing. Accordingly, it is hereby ordered that motion 002 and motion 003 to dismiss the complaint are granted, and the complaint is dismissed. And it is further ordered that motion 004 for renewal is denied as moot. The foregoing constitutes the decision and the order of the New York Supreme Court of New York County. Case dismissed. Another win for Puff. These are the many civil suits that Puffy has going. A lot of them by Tony BUZBEE, who's been exposed as a fraud. And you can look, just keep living, and mark my words, Tony BUZBEE will be held accountable for attorney misconduct. He's already had some situations with Jay-Z and Puff, alleging things that didn't happen, filing frivolous and fraudulent lawsuits. And here is another one, case dismissed. Peace.